So this paper is about something that the Patent Office actually does quite well in my view, and that the federal courts do pretty much improvise on it when they do it at all, which is very rarely. And that is taxonomy, classification. My main argument here is that courts should do it more often, and I'll explain why and where. But because they're courts and not expert agencies, and they would probably not do it very well, what they should do is defer to the Patent Office rather than try to do it from scratch or alone. So first I'll briefly summarize how taxonomy and classification practices sort of underlie pretty much all of patent law, and I think it's a pretty straightforward case to make. I'll explain descriptively how the Patent Office goes about doing classification and why courts don't really classify things very often at all and what effects that has. And then I'll sort of make my normative case for deference. Right, so the case for how taxonomy underlies all of patent law, we have the person of ordinary skill in the art. Right? That is the cornerstone for pretty much all of the major doctrinal requirements for patentability. In the case of things like non-obviousness, enablement, written description, they're written into the statute. And in the case of other things like novelty and utility and claim definiteness, they're not in the statute, but they're implicitly part of the doctrine. And so we always ask first, what is the level of ordinary skill in the art? Who is the person having ordinary skill in the art? And what we very rarely do is ask, what is the art? Before we find out who the person is that fits into that art. And so the Patent Office is very good at this. They've been grappling with this question for a long time, and it turns out they have a pretty good handle on it. So in 1898, Congress gave the Commissioner for Patents explicit statutory authority to command, and the command, in fact, not just the authority, to create a subject matter classification of prior patents, printed publications, everything, so that patent examiners could do their work, quote, with more readiness and accuracy. All the things that we want out of the patent system ex ante. Right? The 1952 Act included this language as well. So under current 35 U.S.C. Section 8, and I actually wrote the majority of this paper without actually finding that statutory command, so glad I found it before today. Patent Office has express authority to do this classifying, and here's how it works. Patent Office gets an application, comes in the door, and we start with centralized intake at the Office of Patent Classification. These are technical specialists who review the application, find out what general technology area it belongs in, what specialized subcategories it belongs in, and finally, through that whole decision tree, wind up at a single class, a single technology class, into which this thing is going to be classified. Right? In addition to that, they also assign search classes, other technology areas that could be relevant to this and where the patent examiner should probably look for prior art. All of that is done in accordance with a manual of patent classification, which was first, as I said, created in response to the 1898 statute. And at the end of that, the person of ordinary skill, the stand-in for which is the patent examiner, is now assigned this case. It's docketed and it's sent to a technology art unit, and all the examiner art units are divided up by technology area as well, and so there's a concordance between technology class and examiner expertise. Off the patent application goes, and during prosecution, because we know that the claims can be revised and adjusted and so on, if it turns out that something that was in class X now belongs in class Y, there's a mechanism for reclassifying. It's rare, but it can be reclassified and rerouted to a different examiner, and that person will take what has already been done and proceed from there. So that's how it generally works. The classification manual is also periodically revised because technology changes. It evolves. Some old things we no longer see anymore. Some small subfield now grows and is its own field with subfields going further down. So all of this is done through reclassification orders that the Patent Office undertakes and issues in a systematic and structured way. So on the basis of this classification process, applications are examined, and eventually some patents go out into the world. Now a very small fraction of those, probably the more important ones, wind up in court, and the validity of the patent is then challenged in a lot of the cases. So courts have to revisit what the Patent Office has done. And this includes trying to identify the person of ordinary skill in the art. Now, I haven't looked at all the evidence yet, but what I've looked at so far suggests that when courts actually look at who the person of ordinary skill in the art is, they almost never ask, what is the art? Right? They never ask that as an initial matter. Sometimes they'll say, this invention pertains to whatever, and that's basically just a statement by fiat with no support for the proposition. But instead, because we have an adversarial system, courts take their cues from interested parties who are making result-oriented arguments and have particular agendas in mind. So you can probably tell from that language what I think of that process. Now, claim construction works this way. We have competing claim constructions. We have infringement contentions that seek a certain outcome. Validity and non-infringement are in tension with each other in much the same way. You can seek a broad claim scope, but you don't want it to be too broad because then it's going to turn out to be invalid. You don't want too narrow a claim scope because, yeah, you'll be valid, but then it won't infringe. So all of these outcomes are what are in the parties' minds, and so as a result, the courts have little capacity or incentive to make an independent assessment of what the field of invention is. Now, the good news is that they don't have to do this, and I'll get to that in a moment, but instead what courts do is basically improvise. They either rely on one or the other party, they make some sort of intuitive assessment. The problem is that there's considerable risk of hindsight bias in this. Even with the best of intentions, and I'll give an example of this. Practitioners for about the last 15 or 20 years have been cautioning strongly against characterizing the field of invention in the spec itself too broadly. Because if you do that, then courts later can use that broad mandate to sweep in a bunch of prior art that, in the patentee's view, has nothing to do with the invention, and they can use that prior art to invalidate that. At the same time, practitioners have been cautioning just as strongly against characterizing the field of invention narrowly. Because if you do that, then courts can use that to construe the claim scope narrowly, and now infringers are going to get off scot-free. Right? So what has happened, people basically just don't characterize the invention at all, the field of invention. There's a field in the spec where you can actually say, the field of invention is this, the invention relates to this. People have just stopped doing that in nearly half of all patent applications that issue as patents. And I found that was very interesting because as recently in the patent systems history, as 20 years ago, that number was closer to 90-95%. And we've seen this decline, and it's been erratic, and it's varies across technologies as we might expect, but it's an interesting trend. And I'll show you very briefly what it looks like. So I looked in the text of a random sample, a weighted sample of 10,000 patents issued from 1976 through 2014, and whether there was a brief summary in the spec of what the field of invention was. And here's what it looks like. Right? Now, this is robust, not as smooth, but robust across technology areas. There's a general decline in chemical. There's a lot of volatility in computers and communications because small numbers in the early 80s. But you're definitely starting to see that drive the downturn. Drugs and medical, electrical and electronic, mechanical, and others. So this is a problem. This is an information suppression mechanism in a literature where we've been trying to craft information forcing mechanisms to have patent owners and applicants tell us what they really think and what they really want so that we can make more informed judgments later. Here they were already telling us, and courts are basically signaling to them, the more information you give us, the more sort of improvisation we're going to engage in with it. So with that as prologue, let me now briefly make the case for courts to explicitly defer to these technology classifications that the Patent Office makes. In general, the normative case is sort of well understood. The agency has technical expertise and over a century of experience in making these classifications. And as a temporal matter, the agency is closer in time to the act of invention, and so they're less susceptible than courts are to the kind of hindsight bias that could lead someone to say, oh, today we know that this invention really pertains to pediatric leukemia, whereas 20 years ago somebody might just have seen this and thought, oh, cancer, and we'll look for all cancer-related prior art. So the further out you get, the more likely it is that the technology will have evolved to the point that a hindsight bias will make an outcome determinative difference. So now let me go back and sort of summarize my evaluation of the Patent Office classification process. It's centralized. It's highly structured, it's adaptable and systematically updated, and most importantly, it's explicitly committed to the agency's discretion by a congressional organic statute. So on these grounds, some judicial deference seems to be appropriate. The question is, how much? Right? Now, I think what the field of invention is a fact issue, much like market definition in antitrust, and the agency makes this initial factual finding on its way to more substantial findings about non-obviousness, enablement, and so on, and finally to a conclusion about validity or invalidity. So this suggests that a technological classification is an informal adjudication in a sort of language of admin law, and the court should respect it unless it finds that the Patent Office behaved in a way that was arbitrary and capricious. So that's basically my thesis, my conclusion. Now, if this comes up under existing doctrine in the context of patent validity, I think it could come up in things other than validity, like doctrine of equivalence, which also requires a positive analysis. But if it comes up in the context of validity, current doctrine will tell us, okay, underlying facts pertaining to validity in litigation for a challenge have to be shown by clear and convincing evidence. Fine, that's still a way of deferring to what the Patent Office did, and still needs to be rebutted by an affirmative argument by the person making the challenge to the validity. And the court still has to engage in an explicit analysis of whether the Patent Office classification was sound or not. And that alone would be, I think, a salutary development. So with that, we'll open the questions.
So, really interesting idea. I really like it. I'm a little concerned, and just as an initial clarification, are you saying if we're going to use the classes or subclasses?
The class and subclass, sort of full classification, yeah.
Well, my concern there is that this might be too narrow, and that if you're doing cross-references and the originating class?
Yeah.
Okay. I'm still concerned, even with that more inclusive grouping, that it might be too narrow, simply because it's not what the classes were designed to do, right? I mean, the originating class is based on the claims, right? The cross-reference class is going to be based on the spec. So you actually could have scenarios where the Patent Office didn't need to be fully inclusive, just as a matter of economy.
Fully inclusive as to prior art that they searched for, or?
Yeah. I mean, only because there's the large literature about the potentially adequate searches that the Patent Office can legitimately do, given the resources they have.
Sure.
And so if we expand it, because now it's going to be a huge fight between any applicant and the Patent Office to ensure that all of the cross-references classes are going to be included for later. And so now I worry about it spiraling. I agree with the expertise points, but I worry about it can be practically done.
Okay, so a couple of things. One is that, I mean, just structurally, this is a rebuttable presumption. So I don't think the court would necessarily be bound irrevocably to whatever the Patent Office did. Second of all, if the claim is that in the court, the claims of patent quality literatures is that courts tend to do, in those high-profile cases, they tend to find what the Patent Office could have done but didn't do. They found prior art, litigants now find prior art that should have been before the court. The only way we can legitimately say it should have been before the Patent Office is if the Patent Office process, working as it should have, would have turned this up, right? So if the class didn't turn it up, then there's something wrong with the class. But there's nothing wrong with the way that the class was applied to the function the Patent Office legitimately does. So that can be a point of greater reform in how well and how precisely the Patent Office creates its classification system. But I think that'd be good. That'd be a more specific and robust feedback loop. Jake?
So I think this field of invention concern is really fascinating, although I think that it kind of compresses two problems together. One which, I'll take what you're saying is true, the PTO does a great job of doing, but one which the PTO does not do at all, and I think no one can really do a great job doing. So the kind of first concern has to deal with the way we think about FOCITAs for claim construction and enablement. All we're trying to do is we're trying to kind of peg the art class. I have that, right? But the problem really comes in non-obviousness analysis, especially for invalidity concerns, where we're dealing with the analogous art test. It's easy to say, what a particular class of invention is. It's really, really, really hard to say what an analogous art is or is not. And by dint of circumstance, you happen to have, the two analogous art people, here in this back corner.
They got one up here, too. So.
Yeah. So, if we want to take, the most extreme example, the In re Biggio case, fine. Obviously, the PTO is great at telling you this is a hairbrush. but they're never going to be good at telling you, well, it's also not a toothbrush, or it is a toothbrush. That's always going to be hard. And so I'm just wondering, like, do the courts give deference to this, like, only claim construction enablement, and then they just kind of go off in the wild blue beyond when it comes to non-obviousness? So, like, just how does that work mechanically?
Sure. So I think your point is well taken, especially as to analogous arts, and I have a section in the paper where I'll talk about it sort of specifically. I don't intend for this to do more work than the Fawcett analysis would already have an existing doctrine, right? So the Fawcett analysis doesn't tell you the person of ordinary skill in the art and all analogous arts. Analogous arts is just a separate thing that we have for 103 purposes, and that's fine. That can stay or not stay as the courts deem fit. Now, once you know what the field of invention is, that's it. That's all they're deferring on. They're not saying it's this to the exclusion of analogous arts, which is a common law sort of superstructure on top of it. And I'm fine with it remaining that way. What it will do is tell us, and I mean, Judge Newman's dissent in Biggio tells us that, you know, if you take seriously the proposition that a hairbrush is to a toothbrush as hair is to tooth, then it's going to tell you much more clearly what it was that the invention really was dealing with, and you can sort of make a more informed judgment about what might be analogous, right? Listen.
So I think it's really interesting. A couple of things. So I guess, like, obviously there's sort of this vein in the literature that they don't always classify well, right? So I've sort of thought it, like, sort of do sort of explicitly push back on that, sort of this idea that software patents are all over the place, that kind of stuff.
Right.
And then also, like, is it almost, I'm sort of curious, like, is it going to be too fine-grained with, you're going by class and sort of subclass with respect to what the sort of field of invention is? Like, to a certain extent, you might want to think of, like, where do you want to aggregate up to so that it's actually helpful in the course to develop some sort of guidance with what's a person of ordinary skill in this field, like
Sure.
with their background, etc.
Yeah, I've thought a little bit about that, because the level of generality problem is something all across law, right? Justice Scalia rants about this in con law all the time. And I don't have a good sort of a priori answer if this approach to classification is normatively better than this other approach. But I think that the way in which a court comes out and says, we're going to choose to go for just the top 3 numbered class and not go so fine-grained as the subclasses below, if there's a persuasive sort of utilitarian case to be made for that, that this is going to allow us to get the right amount of cognitive economy, that inventors will know what they're dealing with, then that's good enough for me. I think that the Patent Office can, in the course of its fact-finding on this question, right, this informal adjudication, can also do more to say, here's why we think this is the right level at which to aggregate, and that could be reviewable or deferrable by the court. But that's something I've only begun to think about, so I think.
Yeah, actually, my question follows really directly on that, which is that I have thought for a long time about what if the possibility of the Patent Office doing a better job of saying something about the person having ordinary skill in the art and what do they do. So the Patent Office might, like, now they give us the class, but the Patent Office doesn't seem to help much on the question, the ultimate question you really want to know, which is, who is this person having ordinary skill in the art? And the tests in the case law are ridiculous and are never used by the courts. Like, the court goes through it, they have this degree, they have this much experience, and then they totally ignore whatever they, decided on it because it doesn't help, right? So if by doing this, focusing the Patent Office on this, one could also encourage the Patent Office to develop some sort of expertise on, kind of what is the person having ordinary skill in the art and what do they know and what are they likely to look at, so that you wouldn't be stuck with, well, we're only going to look inside these two, and after all, not all prior art is even patents. So then I think that might be a really positive development, but if without that, I'd be a little bit worried about, how it's going to really help.
So, I mean, a lot of my friends are examiners, and they frequently tell me how much they get crapped on for, like, they're the ones who couldn't hack it in industry, and so they ran to the Patent Office, where the ordinary skill that they had at graduation now steadily declines as they're removed from the real world of their field. I mean, there's probably some truth to that. I'm not sure that there's as much institutional competence in the PTO today to characterize who the person of ordinary skill in the art would be, as much as there is to classify what the art is. So just as a matter of real politic, I'm not convinced that that's feasible, but that's not a reason not to talk
Well, who
about
else
it.
besides the patent office,
Yeah.
I guess is one way to say it.
That's a fair point, yeah.
Courts can do better.
So is the PTO sort of living in the past here? I mean, it used to be, not that long ago, I guess, that the PTO would do an art search in a very narrow art area. And so what they're looking for, in knowing what the field of the invention is what shoebox am I looking for patents in, or something like that. And now we have electronic searching, and they're going to look far wider, as will litigants and as will anybody, maybe. And I think you're focusing on the question that the statute presents, which is, who is the person whose ordinary skill we are, we only care about what the art is, not for purposes of determining how broadly do we search for prior art, but for purposes of determining whose skill level, from the perspective of whose skill level do we assess whether something would have been obvious or whether something has been enabled. But we don't really do that. We may have findings that get recited before they're ignored. So I'm just wondering if this is a sort of a scholastic exercise in statutory interpretation that has limited bearing on actual practice.
Probably. Honestly, I'll tell you, as somebody who lived at the Patent Office for 4 years, it was very much in the past, but the shift away from taxonomic search alone to keyword search is, I mean, for one thing, it is endogenous on the ability of inventors themselves to combine prior technology areas that seemed very disparate. But now we're seeing that, biology and informatics comes together, 1999, we now have a bioinformatics unit at the PTO, right? So I think that there is some truth to the PTO is living in the world that the patent statute tells them to live in. Now we can update the statute accordingly, and I think the administrative state should follow legislative accountability just as a matter of separation of powers. But I disagree that the only reason we care about the state of the art and what the art is to find out who the person is. Because you can also think about this in terms of preemption and other enforcement problems. Doctrines like, well, let me take the example of preemption. If a court is concerned that this claim is overbroad and it preempts the field of X, then that has nothing to do necessarily with the FOSITA, but we do want to know how broad this claim will preempt other people from coming in and doing follow-on innovation and result in dynamic inefficiencies, right? So there are things besides the FOSITA that the field of invention buys us as a matter of doctrine. So, yeah, with that, thank you very much.